First question, my lords, what would happen where for a subject there is no net exam prescribed? The regulation itself clearly states, my lords, in the regulation that it already passed, my lords, regulation.
Let's see the regulation directly. At which page?
Page 15, and not separately I had given the full regulation, my lords. The page 59, the third page, lords, of the regulation, if lordship see.
Yes.
It is 3.3 point Roman 2.
Yes.
The clearance of net slate set shall not be required for candidates in such discipline for which net slate or set has not been conducted. In every course below specific qualification, there a specific note is given to the same effect.
Yes.
The second question, my lord, what should happen when there are no eligible candidates? This, my lords, I tried to look into whether similar situation has occurred somewhere else, my lord. I could lay hand on a judgment by Punjab and Haryana High Court, wherein, my lords, in the state of Haryana, there are several bunch of matters where single judges have passed judgment, my lords, wherein they have said that they, from 2020, my lords, state of Haryana has taken up a policy to streamline their rules to make it in consonance with UGC guidelines, my lords. Therein, the same situation has arisen, and learned 2-3 batches of matter have clearly said that for there is a extension of lecturers. They were continued, giving every year some extension.
They are not doing that here, they are doing it recruitment.
They are doing it in a different way, but my only concern is that there, the view was, my lords, the view taken was by the learned single judges in series of matters that in so far as for so many seats for which they don't get the eligible, these ineligible candidates were continuing. And in this petition, what happened, my lords, some of those, when
He's wanting it for 1 year, he's complying.
yes, my lords, that's what my only submission is. Why I wanted to bring it to your lordship notice is, in the writ petition, such petitioners who were continued like that, when they were terminated by the state, when they had good enough number of candidates, they had approached the division bench, my lords, and the court has held that they have no such right. But the state can discontinue when they have it. So far, they were continued as a temporary arrangement. Hence, my lords, my only suggestion is that this, I may not, as a counsel for UGC, I may not be able to take this stand, but with great respect, lords, but I leave it to the
We'll pass the interim order. Let them, on the basis of what you say, after some arguments.
please.
The learned counsel appearing for the appellant submits that the directions issued by the learned single judge should be complied with. He, however, points out that there are various be complied with, and the guest faculty would be appointed, and only those persons who qualify the eligibility conditions is stipulated in UGC regulations on minimum qualifications for appointment of teachers and other academic staff in universities and colleges, and measures for maintenance of standards in higher education 2013. Put this in quotes. Shall be appointed as guest faculty. Full stop. He, however, submits that there are various subjects where which the relevant qualifying exams, various disciplines for which relevant qualifying exams of bracket net oblique SLET oblique SET bracket close have not been conducted. He also points out that there is that number of in certain disciplines the number of candidates available would be less than the requirement. The qualified candidates available would be less than the requirement. Full stop. He has handed over a memo regarding the guest faculty details. Has handed over a tabular statement setting out the details of the guest faculties, or the number of the requirement for guest faculty for the academic year 2025-26. Full stop. The same is enclosed with this order. As the same is annexed with this order, appended to this order as and marked as Appendix 1. Full stop. Next. This said tabular statement does indicate that in certain disciplines, such as
Serial number 7,
computer sciences, the number of the requirement far exceeds the number of applicants with the requisite qualifications. Full stop. As an interim measure for the academic year 2025-26, as an interim measure for the academic year 25-26, the appellant be permitted to hire guest faculty in those disciplines, and was also permitted to hire guest faculty or engaged applicants who do not fulfill the qualifications of NET oblique SLET oblique PhD in certain disciplines where the number of qualified candidates falls short of the guest faculty required. Full stop.
and also
Insofar as the appellant's contention that there are disciplines where the qualifying exams NET oblique SLET SAT has not conducted. The Learned Council appearing for UGC has referred to Regulation 3.3 bracket 2
Roman
3.2, which expressly provides that clearing of the said examination would not be required for candidates in such disciplines for which the said examinations have not been conducted. This would address the petitioner's appellant's apprehensions in this regard. Next slide. In order to obviate any ambiguity as to the qualifications of as to the minimum qualifications, we consider it apposite to set out paragraph 3.3 of the aforesaid regulations, which read as under. Just take paragraph 3.3. Put this when we put the regulations.
In that, Lords, only one thing is,
I recorded my submission that we are stating that we will follow the UGC guidelines from this year. My submission, my Lords, was that we are seeking for 1 year extension that will follow from next year. My Lords can reject it because that way it will be better.
The Learned Council of the Appellant submits that for the academic year after smart that way it's said that the appellant would follow the decision of the learned single judge in the academic year 26-27. However, he submits that for the academic year 25-26, appellant may be permitted to engage guest faculty, engage persons who have not qualified the NET, SET and SLET examination, SET, NLSET, SET or PhD, in view of, for two reasons. First, that the requirement in certain disciplines far exceeds the number of applicants. And second, that in certain disciplines, the qualifying examinations have not been conducted.
We make a one submission.
One submission, my lords, in the regulation that the lordships are directed to extract. There is a small amendment that 3.10 is subsequently amended. That's I'm just following.
What is the
That 3. The extract lordships are directed to extract. That 3.10.
we have only extracted 3.3.
Then no.
Then only extracting 3.3.
Yes.
Paragraph 1 and 2.
No, then no.
That is the relevant.
Yes.
But may we make a request where before the learned single judge, but we are not parties before the learned single judge who has filed the present writ petition which is impugned by the order. But we have also filed a writ petition challenging the seeking review of that learned single judge order which is pending adjudication.
We are keeping this pending. That's what we want.
Yes. No. Now you by virtue of your lordship's order.
Only an interim order.
Yes. Because in the other batch of writ petitions.
Our counseling is happening now.
Yes. No. What happened is Millard from past.
Because it's happening now. So there has to be some directions to.
No. We have been continued by virtue of the interim orders passed in the earlier batch of writ petitions. We are working since from past 15 to 20 years as a stopgap arrangement by relaxation by the UGC regulations by the state government. We have also been continued by the learned single judge where 25-26 notifications are issued. That has been stayed. Therefore, by virtue of your lordship's order, the batch of writ petitions where we have obtained an interim order, we are nowhere.
You're right there. You'll be right, but we have examined this position and we agree with what.
Therefore, the petitioners who are already working on since past many years, who are under by virtue of the shelter of the interim orders in a batch of other writ petitions, may also be protected. Our request,
It can't be protected. This will never end.
Otherwise, we have been condemned without hearing, even before the learned single judge where we sought for review. Interim orders are operating in a batch of writ petitions. The state government will produce your lordship's order and the interim orders will be modified.
Petitions were being deferred. Lords not awaiting. Lords, what happens to the writ appeal? And Lords, based on either this interim order will be placed. And Lords, we had stated that till an order is passed in the writ appeal, the existing status quo will continue because the classes have to go on. So now Lords will be placing this order because
they have not.
And Lords counselling has to be held. That's
no,
the status.
The counselling everywhere. I shall for 2 minutes. These guest faculties are not continued from past several years.
There is an order passed by the learned single judge. We have examined it. We don't find any error in it. What do you?
We are saying
on your
where your lordships are examining the writ petition with the learned single judge orders where we are not the parties. It is some of the other candidates who have filed. Therefore, we sought for review of that order.
Qualifications are to be decided. It's not that every possible candidate is required.
That is on the ground before we sought for review because the UGC regulation itself will not apply because the persons who have been working, the UGC regulations the state has not adapted and the payment is not by the UGC. That is the view is taken by the Supreme Court.
I'm not arguing that. I'm not arguing that.
Are not applicable. Their case is that guest faculty is not.
No, they have been appointed by virtue of a special rules. Look, the state government has appointed us by virtue of a special rules continued from 96, 2010 and 2020. But that is not, they have not argued. Because they have not argued, we will be, our rights will be at bleak, Lord. We have also obtained the interim orders. Now the learner single judge, Lord, by virtue of the modification, it will be affected without hearing.
We must obviously follow from this order. This order is obviously would follow if the learned single judge had reviewed this order.
In fact, what happened was,
If your lordships are concurring that order, it will not arise.
there was one writ petition which was filed, my lords, where the prayer was to seek for review, my lords, of the order, of this order, where the learned single judge had passed. So that writ petition was placed before the very same learned single judge. All the other writ petitions which were filed, in fact, got connected to that, and it's before the very same learned single judge. He is awaiting, my lords, the orders by the division.
See, there are two issues.
We will place it before the court.
There will be an issue because if he is saying that there is another argument,
Please.
that UGC rules are not applicable,
No,
somebody will have to examine it.
Yes,
At some stage.
if
Till
that,
then,
Till then, there has to be some prima facie case. In our case, we are not prima facie accepting that view, but assuming that you want to have your say, we'll have to find out.
No, my lords asked me a pointed question. If I'm appointing a regular lecturer, will these regulations apply? And I answered, my lords, it applies. So the fact that they are
Your only argument was
is that guest
that
lecturers
is
stand on a
usually-
different footing.
that guest is not contract appointment
Please.
and it's separate.
That was my argument. I stand by that argument, my lords. And in fact, when my lords, in so far as the regular appointments to the first grade colleges are concerned, I am following the UGC regulations. So there is my learned friend saying that we are not.
They've been appointed in some special.
special rules, yes. There are special rules. 96 rules is there, 2010 rules is there, 2020 rules are there. If I provide an opportunity, I shall argue that.
Well, this is list for hearing. Have you filed your
There are impleading applications which are still pending.
Where is your impleadment?
IA number. Single judge.
No, you tell us here, we'll implead you if you want to hear us, and we'll, because we are not prima facie following this argument that UGC has one regulation where regular
Alternatively,
or regular faculty will be done by that regulation, but some special carve out will have to be made for you, and that should be continued in perpetuity. That's not something that we are readily
May I
willing to accept.
alternately request another prayer? If your lordship may keep it open, the review petition, we will also argue there in the next week itself.
We need to close this. There is some certainty to everybody.
Yes.
And this is not a way to go about certainty. That's the reason why we are not disposing of the petition and something else comes up.
Now we are on
We can-
this week, my lord.
It's not just 15, 20 years. You had the option to get those qualifications. The qualifications are there in regulations. You can't perpetuate by, and this argument we heard by one of the councils who appeared espousing it, by saying that there is persons of 55 years and 54 years. We can understand that there is an issue here as far as your inconvenience to you is concerned. There will be prejudice, but does it mean that the qualifications has to be relaxed? We are not able to follow it.
May I make one something? There's one more issue which is not decided in this present impugned order was the MPhil, those who have passed MPhil qualified candidates are exempted from this, my lord, NET and SLET.
Those who are,
Passed MPhil as on 2009 prior to 2007.
we are saying this.
That is not decided in this
As far
case.
as the UGC qualifications are concerned,
Yes.
that will apply.
No,
Even my lord, they are exempted and state
If they are
government-
exempted, they are exempted.
That issue is pending before the single judge.
We put that.
Yes, my lord. That clarification may kindly be given.
The other issue
That is not issued. That is not decided here, my lord. Please,
That's not decided.
yes, coach.
even for technical, yes.
That we have to. I have clarified, my lord. We can much before that.
There are certain other
Those who
persons
are
who
qualified
are
MPhil, my lord.
claiming exemption from UGC, who claim that there are specific exemptions granted by UGC from in respect to the aforesaid qualification. It's needless to state that if there the UGC has exempted certain category of persons from the applicability of those the aforesaid regulations. The said exemption, if any, would this interim order will not affect.
Yes.
Thus, the exemption.
Ladies,
Here you want to plead.
My lords, if I may be permitted, my lords, it is not so easy for these petitioners to register for PhD, my lords, or to appear in these examination. The passing rates are very less, my lords. It's not that they have not tried at all, my lords. They've been trying.
There are candidates who have crossed this exam. If they are available, then obviously the students will have the benefit of those. There is an expert body that has framed these regulations.
The state will
The
have to
fact
take
that-
some policy decision for the number of years they have served here, my lords.
Policy decision is a student should get best education.
It's not that we are not teaching, my lords.
So if the threshold has been fixed by the UGC, that has to be crossed.
Last year also they did not conduct any counseling. They have been continued. Therefore, let the state requested, please continue for another year.
Our hands are bound by the law.
Unless we come to that, that is why we wanted to
that these
demonstrate
regulations
before the
of
court.
UGC do not apply. We can't help.
No, we are.
It's not available for us to alter the statutory regulations on even if you are persuaded to. So all we can do is give some sympathies, but we can't give you.
That is why we wanted to request before the court to give an opportunity of hearing.
We hear you.
Till it is been decided.
As far as this academic year is concerned, this interim order. We'll hear you on that.
So that
If you are
they will be out of service, Millard. They will be out of service. The persons who have been taught for, now all of a sudden the persons who have been taught for 20 years, now they have been said you are not qualified.
this service is not a regular service.
Yes.
You've been appointed year to year.
That is like Manish Gupta's case, your lordships are aware, the Supreme Court in a guest faculty's case only have heard, unless the regular recruitment is there, you cannot be disturbed. You have been continued.
Also, one set of guest lecturers cannot be replaced
By another set of guest faculties is also there. But if this order is being given effect to by the state government,
Faculty have to appoint.
that is why we requested a kindly continuous which have been continued earlier, and hear us, and another for 2 months or 3 months, so that the pleadings will be completed. We will address our arguments. Previous also year they have taught, now continued. The persons who did not. That is the problem.
The latest regular, we appointed 1,400 people.
Total number is some 10,000 and 7,000 is regularly appointed lecturers. 3,000 may be fluctuating because of various new courses or such kind of or absence of students in some particular places. But that cannot be 2,000, 10,000.
In affidavit, increase in strength and other things.
You tell us.
10,000 is only regular. That can't be.
We'll hear you on your point if you want,
Yes,
but that's post interim order because we don't find any primary.
we are also requesting the court. The lordships now have exempted the subjects in which the qualifications are not there. Not there. We have also standing on a similar footing where we have been extended from last 15 years.
Where there is no eligible candidate, obviously they'll still have to run the point. You're not
Therefore,
eligible candidates being there who are not being appointed because you are employed there. That's the issue. But you tell us, we'll hear you also.
It is not the case where there is a scarcity. They have been.
You can't hear arguments in this manner.
Yes.
You have a point.
Yes.
To make on this, you make the point, we'll hear you. This order will stay.
All pleading applications, intervening could be allowed so that if they have
That's
to make
right.
a point, let
We'll allow it.
please.
But let them not disturb our.
No, that's not correct. So there are a large number of
Even before the learned single judge.
large. Just give us the implement application that you file. We can't hear 20 applications. You'll have to demarcate on who are the existing ones, who are not going to be heard. We can't hear 20 councils on an implement.
So I think the main implementing applications were filed by UGC qualified candidates who are on the other side. Maybe now that their interest is protected, I think their
Item number 18, your lordships.
So UGC candidates were, and we are accepting that prima facie. So you can watch these proceedings. If anything adverse order comes to be passed, and you can
Please,
Sir, all the applications be listed, but not on some other
wait
date.
all of the applications listed on your date list on dash for further proceedings. All applications for implement and intervention be also listed the next day. Or just list for further proceedings and stuff. The endeavor would also be made to hear the parties seeking implement or intervention, public intervention in the present.
We are also requesting one more request, my lord. The contentions which you have, your lordships now dealt with, that contention which you have sought to be reviewed may be kept open, so that we will also address if it is that reviewed. But
An interim order, that's why we have placed it in interim order. The appellant also wants to,
because the kindly see a situation where the interim order is division bench's interim order is placed before the learned single judge, but he will say nothing to consider, it has been modified.
we understand, that's why we are saying you want to argue anything, we give you full opportunity to argue. You can't say that
We are not.
no, you are not arguing here, but we must now protect you on grounds that we don't agree. As prima facie, if you persuade us, we'll pass a final order. We have yet to pass a final order in this appeal.
Next week, Mulati, you will it will fix it so that our rights will be
I'll
crystallized.
give you a date. This has been put urgently for the mentioning by the learned council that the counseling is happening today. That's why we're giving you 2 weeks time. You make your written note with whatever authorities you want to rely on. Be ready.
8th of October.
Parties are at liberty to file a short note of submissions, propositions along with the
List of site authorities.
along with all the list of relevant authorities. Not parties, the council. Council.
Grateful.
17.
Number 70.
Please, lordships.